Hello, I'm Susan Miranda. I'm an associate.
I'm Jessica Ra and I'm an associate. We work at Michael Lynch Family Lawyers.
We wanted to speak today about a few different topics. The first topic, though, is you've been served with court documents. What do you do next? Firstly, remember you have 28 days from the date you were served to file your documents in response. If you have a legal representative, they will ensure that your court documents are filed in that 28-day period. It is not a hard and fast 28-day rule. That is, you can still file after the 28 days has lapsed, but remember that the registrar or judge who you're appearing before on the first return date will be looking to when did you file. And also what documents you file will depend on what orders are sought in the initiating application. For example, if it is a property matter, you'll be filing a response to initiating application, an affidavit and a financial statement if you are in the Federal Circuit Court. If you're in the family court, it might be different again. If it's a parenting matter, you'll be filing a response, an affidavit and a risk form.
So once you've filed your documents, it's important that any correspondence that you receive from the court, it will most likely be by email, that you follow the directions in the court's correspondence. This is really important because there have been people in the past who haven't actually read the directions in the court's correspondence and then have actually not phoned in as they were supposed to, and have actually missed the appearance. So it's really essential. Make sure that you read the court's correspondence and it will make things a lot easier for you and you'll feel a lot better if you do so.
Often I've found that lately with COVID, most appearances in court are by telephone, but there are other ways. They might direct you to be physically at court, or it might be by Microsoft Teams. So it is important to read the emails from the court. And also, if you're in court, and make sure you've got your phone. If it's a telephone appearance, your phone is on mute if it is not your court matter that the court is dealing with at the time. It's very difficult for the judges to hear what's going on during telephone appearances. So everybody if it's not your matter, have your phone on mute. Don't put it on hold either, otherwise the hold music comes over the court phone and the court can't hear anybody. Now, if it's the first return date, if you're going to be in court physically, make sure you're dressed in your Sunday best. Make sure you've removed glasses from the top of your head when it's your matter, and make sure your phone is turned off. If it's a phone appearance or if you're in person, the judge is referred to as Your Honour. If you're in court and the judge is speaking to you and you're at the bar table, you should stand. And if you want to speak to the judge, you should also stand. Ensure you don't interrupt the judge or the other party or legal practitioner if they're speaking. Wait for your turn, you will get an opportunity to speak. If you're legally represented, then your legal representative will be speaking on your behalf. You'll likely be sitting beside them or behind them and be able to whisper instructions to them should you need to do so.
Yeah, so first impressions really do count, so those are some really important tips. Something else to be aware of as well is that judges will sometimes conduct what is known as a call-over at return dates for matters. So what that effectively means is that the judge will get all matters that are in their list and asks for an appearance, which is quite short by each party, to really work out the crux of the matter and then allocate the matter priority in the list. So it's important that when you do attend for these call-overs, stay calm, listen to the question that the judge is asking you if you are self-represented, answer it truthfully and correctly, and it should run very easily and the court will then allocate your matter accordingly.
The judge doesn't really want to know the full story about your matter in the call-over. It's really just very short. Is it property? Is it parenting? And actually, if your matter's stood in the list, that might give you time to negotiate with the other party whilst you wait for your matter to be called.
That's common.
Yes. Now, directions hearings. Your matter might be allocated just for a directions hearing. Often that happens with property matters. That is, the court just wants to make directions about your matter to help it proceed more smoothly through the court process. Directions can include directions for disclosure of certain financial documents. It can include directions for evaluation of property that is in dispute, and directions for a mediation or a conciliation conference.
So some things to also be aware of is that the courts are running a number of trial programs. One in particular is the Lighthouse Project, and this program is important because it's really showing the court's recognition for the serious issue of family violence. So what this program involves is parties actually being given the opportunity to complete a questionnaire, which is done online, and then the court can effectively triage the matter, and if it's necessary, because there are serious allegations of family violence or abuse, allocate the matter to a very well experienced judge who has a lot of experience with those types of issues.
The Lighthouse Project, I think, also gives parties some reassurance that their matter, where there's urgency, might be dealt with more urgently than other matters.
That too.
Yes. We've covered a lot of topics today, but rest assured there's more information about all of these topics and more on the Family Court website, the Federal Circuit Court website, and also Michael Lynch Family Lawyers website. And don't forget, you can make an appointment for an initial consultation with a lawyer here at Michael Lynch Family Lawyers so that we can give you more specific advice for your particular matter.